Fair lending is a big issue in mortgage. What's going to happen with the new administration? This is a mortgage banking live stream. Welcome. This is the mortgage banking live stream. Today is November 4th, 2020, day one after the election, kind of. And today we are going to be talking with some amazing people that spend a lot of time focused on fair lending, involved with companies that are facing fair lending cases. I'm Troy Garris Horn. We're here to educate, to connect, to entertain. We're going to talk a little bit about politics, a little bit of business, and then we're going to jump into the regulatory aspect of this. As we get started, a couple shouts out. MBA's Reg Compliance Conference, normally in DC, of course, virtual, of course, is November 9th and 10th. That's next week. And if you haven't signed up for that, you will definitely want to do that. Similarly, MISMO has asked for comments on its new API toolkit, and they have a 60-day period. So if you want to comment on the API toolkit, now is your time to do so. People are always talking about how regulations and how systems don't account for the various aspects of their business. This is a chance, an opportunity to get your voice heard. You should reach out to the NBA and take advantage of that. The Texas NBA also is having its Texas NBA's annual symposium, November 17th and 18th. It's also having its reverse mortgage days, same time. And you definitely want to sign up for that. It's always a great event. Lots of helpful information, great speakers, interesting speakers as well on some different areas. They always have one keynote that is outside the mortgage industry that has a different take on the world. And you'll definitely want to check that out. Couple of thanks also to some of our supporters. So Suha Zell, Suha, great to see you here. Thank you very much. Mike Lee, great seeing you, Mike. Michael Jones, Joy McGee, everybody, thank you so very much for the support. We do appreciate it here, and we wouldn't be able to do this unless you needed this information. You send us over the topics, and we get those topics on. So if you want something addressed here, just send me an email, send me a text, you can call me. My contact information is in the YouTube channel, just in the description, just below this, and we will get your information on. The elections are not yet quite done, right? The voting ended yesterday, but we still have a number of swing states that are still in the counting process, and we will not know. Nobody really knows, but probably at least as far as the initial call until sometime later this week, maybe even Friday, and then on both sides, we're already hearing and seeing instances of litigation, and this process will still go on for some time. On the business side, loan applications are up just under 3%. That's a good sign. As we see week to week, there's a little bit of application numbers down, a little bit of application numbers up, and it's always helpful to see that sign, because really that's the sign of a healthy market. It's not a bubble. It's not declining substantially. It is that's the sign of a healthy market. One room for caution, though, is that multifamily and commercial borrowing has fallen in third quarter of this year, fallen 47%. Now, people can speculate as to what that means, and of course it's an aggregate number, and all real estate is local, but it is sort of disturbing, and we will definitely need to keep a watch on that. Now, this channel itself is focused primarily on residential mortgage lending, but certainly commercial lending has its place in the economy and is also a bulwark of our economy. And so, that much of a decline is a cause for pause as people consider how this is going to shake out in the coming months. One other good sign, though, is that loans in forbearance are down yet again, down below 6%. That is a good sign for sure. There's still a lot of uncertainty out there, and now, depending on how the election comes out, most people are thinking that there will be additional stimulus, and hopefully that will help out if that comes along. Breathtaking numbers they're talking about, though. Every time you hear on the news that they're talking about $1 trillion here, $1 trillion there, and that will definitely be cause for a lot of conversation in coming months. couple more thanks, and then we're going to jump into the conversation with our two guests today. Trey Worley, thank you, Trey. Dustin Pfluger, Dennis Lanab, great to see you here, Dennis. Ian Wright. There's just so many amazing people on here that are supportive, and we do appreciate it. Laura Brandeo, thank you so much, as always. So today we're going to talk to Rich Horn of Garris Horn and Sean Burke of Mattingly Burke. And these are two gentlemen that are often involved in fair lending cases. And they're involved in a lot of other kinds of cases too, but in particular, they've been focusing a lot on companies that are facing fair lending challenges. And I thought it would be interesting to get them on today and talk about what's been going on, and then also the types of cases that they're involved in, and then also what the new administration, whatever administration that is, might mean for these types of cases. So, gentlemen, welcome to the show, and we are glad to have you on. And welcome, as always, Rich Horn and Sean Burke, to both of you.
Thanks, Troy.
Thanks for having us.
So, gentlemen, I know that there's a lot going on. I know that you're involved in a lot of different things, but Rich, can you just give us a brief synopsis of what's going on fair lending wise over the CFPB or otherwise right now?
Yeah, that's a great question. And Troy, as you're well aware, our firm has had a couple of fair lending investigations with the CFPB, and what we've seen is a focus on redlining and marketing discrimination. Whether applicants from certain majority minority neighborhoods were discouraged from applying to the lender, and that is something that the CFPB has actually messaged in their own fair lending reports. If you look back at the last couple of years of public reports, they've said in no uncertain terms that their focus on mortgage origination work and the fair lending office is on redlining and marketing discrimination. So it's not shouldn't be a surprise that we've had a couple investigations, and we've heard from our friends at other law firms that they've had similar investigations as well. So the scuttlebutt around the industry is that this is an active area in the enforcement space, but also in the supervisory space as well. So we've heard of an uptick in activity in fair lending examinations for these issues as well. So I think at least at the CFPB, this seems to be the focus. Now, the one thing I want to highlight, because this might not be expected by your listeners, is that this involves not just depository institutions, which typically have been the focus of fair lending, especially redlining and marketing discrimination claims in the past by the government, but this also includes non-bank lenders. So you mortgage companies out there, if you think you're immune from having these types of fair lending exams or investigations from the CFPB or other agencies, that doesn't seem to be the case anymore. And you can tell this from the recent lawsuit that the CFPB filed in July against our client and Sean Burke's client as well, Townstone Financial. That lawsuit is a redlining marketing discrimination case where the CFPB is alleging that Townstone, a non-depository mortgage company, discouraged potential applicants from the south side of Chicago in those majority African American neighborhoods from applying. That is something that I think everyone who's listening here should be afraid of, because obviously a non-bank mortgage company doesn't have a Community Reinvestment Act assessment area, which is typically the linchpin for these cases when they're against banks, where the federal agency can say, look, this bank definitely intended to exclude these majority minority neighborhoods because from their assessment area, you can tell they've carved out that majority minority neighborhood from their market area. And the cases have described their assessment area under the Community Reinvestment Act as horseshoe shaped, or other types of terminology to just describe it as indicating an intent to carve out certain neighborhoods. You don't have that for a non-bank mortgage company, so the CFPB had to rely on other facts in the Townstone case to try and allege a marketing discrimination claim, and we can walk through the facts in those in that complaint fairly quickly, so that your listeners can get a sense of what other facts the CFPB is looking at to make a marketing discrimination claim. One is that Townstone didn't market specifically, didn't target its marketing to African Americans. Two, that they didn't employ an African American loan officer. And three, that Townstone, based on the HMDA data during the relevant period, had a statistically significant lower percentage of applications from the majority African American neighborhoods in Chicago than quote unquote peer lenders. And that's based on a HMDA peer analysis, which some of your listeners may be familiar with. And those are three primary facts in the case. One other fact that's gotten a lot of attention in the case is another major fact in the case that it really was talked about a lot in the media, and definitely we focused on a lot because it is very troubling. The CFPB also called out in the complaint that Townstone was marketing through a radio show and a podcast on an AM conservative-leaning political radio station in Chicago, AM 560, and also on a podcast on a talk radio program that they called the Townstone Financial Show. And the CFPB called out about 5 statements and saying that those statements, short statements in particular, discourage potential African American applicants from applying to Townstone. And so, by calling out those statements, they really called out the content of Townstone's speech on this show on a politically conservative, politically leaning radio show and podcast. So that is something that's obviously troubling, that raises First Amendment concerns. But first, for your listeners, I want to point out the other industry concerns about this case, and that by focusing on the fact that Townstone didn't have marketing that was targeted to African Americans, and also that it didn't have an African American loan officer, what the CFPB is effectively doing with the case, or trying to do, is create affirmative obligations under ECOA that don't exist. If you look at the statute ECOA or the regulation, you don't see in there that creditors must target marketing to every single demographic in their market area, or they must hire loan officers. There's no hiring quota in ECOA or Regulation B that says that lenders have to hire loan officers from every single demographic in their market area. And so the CFPB is essentially creating these affirmative obligations under ECOA for all lenders, or trying to, for all lenders through this lawsuit. Also, what the CFPB is trying to do is use disparate impact by saying that Townstone wasn't able to generate enough applications from African American neighborhoods to pass muster in the CFPB's eyes by using this peer analysis, where the CFPB says that they didn't have they had a lower percentage than the quote unquote peer lenders in the MSA. That is something that is essentially a disparate impact test. It's an effects test, and ECOA doesn't have statutory language that allows for an effects test. When the Supreme Court heard the issue of whether disparate impact was an allowable theory under the Fair Housing Act, the Supreme Court found that it could be based on a certain results-oriented language in the Fair Housing Act statute. Well, ECOA doesn't have that same language, and so the ECOA doesn't really support this type of effects test. And so the CFPB is trying to use disparate impact when it really can't under ECOA. And then
it seems like it's trying to feel through that, right? Like the trying to expand where language currently isn't. Is that kind of the gist that I'm getting? And actually, Sean, jump in as well. Where I know that you're actively involved in the filing just recently of, I think it was a motion to dismiss. Is that right? You want to talk a little bit about where we are in posture and how that relates to what Rich is talking about?
Yeah, no, that's right. Thanks, Troy, and thanks, Rich, for the lead up. And Rich was talking mostly about how the Bureau and the Regulation B and the Bureau's interpretation and implementation of Regulation B has really run afoul of the statutory regime, and that's important. And that's a big part of our motion to dismiss. But in the factual lead up, he also talked about that this case is largely based upon 4 to 6 statements that were made by Townstone on the Townstone radio hour, right? And so that's speech, right? And when you get involved in the speech world, you obviously look at the First Amendment, right? And the First Amendment protects, all kinds of speech, political speech, commercial speech, and it does so with a heavy hand, right? There should be no law, right? And but what we've seen here is it's not just that you can't speak. In order to determine that Townstone's speech was allegedly bad, they had to look at the content of the speech. So this is a content-based regulation that always requires stricter scrutiny under the First Amendment. And it's not just a content-based restriction, it's got its twin other problem. It's viewpoint-based, right? So there's Reg B defines as definition of discouragement, and I'm not going to get the exact language right, but basically you can't do anything to discourage applicants or prospective applicants, right? And so that's a viewpoint. You can't discourage, right? So it's content-based and it's viewpoint-based, right? And so in order to pass muster under the Constitution, they have to prove, the Bureau does, that it's substantially related to a compelling state interest. And no one on this podcast or no one on, is going to challenge that, preventing discrimination is not a compelling interest because it is.
Sure.
However, this doesn't fit, right? There's all kinds of ways, consumer education programs, more speech that you can use to not regulate the speech in this way, right? I think it's important, in addition to the fact that they're looking at these 4 to 6 statements at their content to say this speech was bad, but then they also, as Rich mentioned, they're creating an affirmative obligation to speak, and who you have to speak to by saying you are bad, Townstone, because you didn't affirmatively advertise to certain areas. Now, that happens to be factually wrong in this instance. However, even if it weren't, creating obligations to speak is crazy, right? Number one. And number two, there's nowhere in the enabling regulations that allow for that, right? And so that leads into kind of the last constitutional concern that I'll speak about today, which is protected under the First and the Fifth Amendment. It's a void for vagueness doctrine, right? So, Townstone's owners and the participants in the podcast will tell you, I had no idea that any of the statements that I was making that were to educate and to entertain were at all problematic, right? Because if you look at ACOA's regulation and even Reg B, it doesn't give you fair notice of what is prohibited and what is not prohibited. And so, that is, so all those things, jumbled up together, were part of our motion to dismiss. So now the Bureau, of course, gets an opportunity to respond, and we're anxiously waiting to see what they have to say. They're smart people. They're smart government servants, and so we anticipate that they're going to have a lot to say. But then we get a final chance to make our case as well. So that's sort of generally the basis for our motion to dismiss.
And Rich, what's the next step in this particular case? I know that you guys have filed your motion to dismiss, but what happens next?
Yeah, before we get to that, Troy, I just want to mention one thing, because Sean, you said something that made me think that we need to make this point clearer, and I may not have done that when I was describing the facts. This radio station reached all of Chicago, including the South Side neighborhoods, all majority and minority neighborhoods in Chicago, and reached neighboring states. If you look at the coverage maps for all of the radio stations where Townstone was advertising, they all reached all of Chicago and neighboring states. And obviously the podcast was on the internet. So there can be no allegation of physical redlining here, like there is in traditional redlining cases where a bank really does carve out a certain area from their assessment area, and there's not physical marketing in those areas. Townstone was marketing to all of Chicago. So another way to look at the Bureau's argument is it doesn't matter if you have general marketing that can reach everywhere. If you don't target marketing to certain demographics, that's a violation of ECOA even. So what they're doing is turning ECOA, which is really a statute of exclusion, into a statute that requires inclusion of everybody specifically. And you have to be able to prove to it looks like the Bureau wants you to be able to prove to it to avoid prosecution that you've gone out and tried to get and tried to advertise to all demographics and tried to hire loan officers from all demographics. The other thing to point out is Townsend actually had a very diverse staff. They had African American loan processors, and they had a Hispanic loan officer.
And a very small company, right?
Yeah, for a very small company. I think during most of the time of the relevant period of this case, Townsend had at most 6 loan officers at most. Right now, they're a 3-person company, and so this is a tiny company. And so regardless of how diverse your staff is, if you don't happen to have a loan officer of the demographic that the Bureau cares about in your case, that can be viewed by the Bureau as a violation of ECOA. So this legal theory is very, very, very troubling. It's very problematic. Unfortunately, you pointed out a very important point, Troy, that this is a small company. They don't have a lot of funds to fight the government. It's definitely a David versus Goliath situation. And so Friends of Townstone have created a website to try and help Townstone fight the government in this case, so that this legal theory, if unfortunately Townstone has to settle, as we all know, in financial services, people view settlements as precedent, especially regulators. And Director Cordray himself was on the Hill saying that if compliance officers and attorneys don't look at their consent orders and try and avoid the facts in them, then they're committing compliance malpractice. So the regulators will expect you to obey the fact, to avoid all the facts in a settlement and consider it precedent. And so if Townsend is forced to settle, that'll unfortunately become precedent for the industry, and this would be a very troubling precedent. So Friends of Townsend have put up a website to help it defend against this case for as long as it takes. I mean, this could be a Supreme Court case potentially. Right. So
and you guys have some other co-counsel involved too, right? Like I think Jim Bopp, the famous First Amendment attorney, and others included, right? And so I guess why is the CFPB going after such a tiny company unless it just believes that something going on there is particularly heinous, or and also I guess how is such a small company able to sustain that sort of an onslaught?
Yeah, if you go to the website, www.townstonefightsforfreespeech.com, you'll see that there's a whole description of the problems with the case, as well as a way to donate to the James Madison Center for Free Speech.
Right. Just
support Townstone, and I think I'll let Sean take the gavel to discuss the potential reasons why CFPB brought the case against this small company. But it is very troubling that this legal theory could be
it becomes sort of quasi law, right? If this consent order comes up.
Well, and I'll try and tie this back to kind of where you started, Troy, as what happens with the election and where we go from here. And so there's a couple of trends, maybe a few trends that we've been seeing as litigators who deal with the Bureau on a regular basis. First of all, the Bureau seems to, in our view, inconsistent with its mandate, seems to be pressing the outer bounds of its jurisdictional limits, right? It's wanting to use Regulation B in this instance to regulate speech and to mandate hiring practices. There's other instances where we're aware that they're trying to press regulations into, home security, for example, and things like that the Bureau really ought not to have jurisdiction in. So they're really trying to push their jurisdiction. And so that's a concern that we have, really as citizens. Second, they seem to be doing so in several instances against the little guy. Right. And, whether it's strategic or whether it's not strategic, I'll let the audience decide. But the Bureau is taking these fights to expand their jurisdiction, and they're doing it against people who ought not to have the resources to fight them. Right. And then the third trend that we're seeing is not only are they going after the companies that are allegedly, engaging in bad behavior, but they're also going after the principals and seeking enormous fines and bans in the industry. And so it's this really aggressive regulatory behavior that we're seeing. And, one of the other, so I'm a partner at Matty Lee Burke, Cohen and Biederman. I also am a founder of Proteus Discovery Group, right? And when an entity gets a CID from the Bureau of Civil Investigative Demand, just the receipt of that and complying with that is tremendously expensive, because there are collection and production requirements that are really, really difficult to deal with. And so you have to have specialists like us who can have the expertise to respond to that, right? So just the fact that you're getting a civil investigative demand really can affect your balance sheet. But then when you take it to an enforcement action, it gets really, really difficult. And so our client feels these concerns acutely, right? And is blessed that some people, including James Bopp, who you mentioned, Mark Sturko is one of the foremost RESPA lawyers in the country, have also banded together and created this website. And you can donate to our partners at the James Madison French Center for Free Speech. That will hopefully allow Townstone to continue this fight, because it doesn't want to be the straw that broke the camel's back, so to speak, on this issue, right? And it wants to, not only does it want to not be that, but it wants to defend its own reputation, because it's offended by these allegations, and very much wants to clear its name. It doesn't want to be forced into a settlement and a consent order that it doesn't like. And so one of the things that I find interesting, regardless of which way this national election goes, this presidential election goes, is to determine whether those trends will be continued by the next administration, or whether whoever gets in there decides to pull it back, right? We had these statements by, the prior director, Mulvaney, talked about respect for the people that were regulating and working with business. And we feel that the Bureau's actions lately have been inconsistent with that, and are hopeful that whoever's elected will sort of rein the Bureau back in and give more clear direction. And, it's always almost trite that, the regulation by enforcement, but that's what our clients are feeling these days. And so that will be something interesting to watch, in the weeks and months to come.
Yeah, it's very interesting that this push for being able to allege redlining against non-bank mortgage companies, which is something new and quite frankly historic. It hasn't been done before. All of the past cases have been against banks, as I mentioned. That it's happening under a director of the Bureau that was appointed by a Republican president. You wouldn't expect that. Attempt to expand the CFPB's authorities to engage in regulation by enforcement, all of that is happening under a Republican appointed director of the agency. And then you think, what happens if we have President Biden, and he gets the opportunity to appoint his own director of the CFPB, either by removing Kraninger or if Kraninger resigns, which could happen soon after President Biden is inaugurated. That could unfortunately result in even more action in this area. I don't think that they're going to say, "Oh, well, this is too far over the line for our authorities." It's just not something you can expect from a Democratic appointed director of the CFPB. I think they would go even further. So you would see perhaps more investigations, which are very costly, as Sean mentioned, and especially if it's an investigation against an individual principal of a company, which they can do for non-bank mortgage companies. That becomes costly for the individual as well. Unfortunately, if you were a CEO of a small non-bank mortgage company, or even medium-sized non-bank mortgage company, or a high-up staff person, and they're going after you individually as well as against the company, that's going to affect you personally. Unfortunately, we've seen clients who've been under personal investigation by the CFPB have to tap into retirement funds and their kids' college funds, and so this is real deal. And unfortunately, it's really problematic that the CFPB right now is trying to create weapons that a future Democrat-appointed director of the bureau can use even more. So I think we really
I
need
guess
to
we'll
make
know.
sure that the CFB is brushed back. Yeah.
I guess we'll know January 21st what that's
Oh, we'll
going
know.
to be.
Yeah.
Maybe not until then. We don't quite understand at this moment. Well, listen,
Yeah.
gentlemen, I know you guys have a ton of things going on, and I do appreciate your time here and sharing your thoughts. Best of luck, of course, in that litigation. I do think that there is a lot to unpack here, and people do need to be paying attention. And so I do appreciate your insights. We'll love to have you back on the show in the near future and hear more about what's going on, at least on the public side, that you can talk about because we know you're limited in that sense. But
Yeah, and I'm sorry about being overly dramatic. I mean, you might have to change your theme song, Troy, to some scary Halloween music. Next time you have us on.
I will definitely think about doing that, depending on what happens in the next round.
Yeah, that's right. Could be celebratory music,
right?
Maybe.
Well, gentlemen, thank you so much. We will see you again soon, very soon, hopefully. And again, best of luck in that. Thank you, everybody, for your support. And hopefully this information is helpful. If it is, subscribe, ring the bell, share it with your friends, and make sure that they get this information too. And we will talk to you again soon. I'm Troy Garris at the Mortgage Banking Live Stream.